Good day, everyone. Today we are here to discuss the fourth article of the 1987 Philippine Constitution, which is all about citizenship. To start off, let's take a look at the definition of citizenship. Citizenship is a legal relationship between an individual and a country. Citizenship is gained by meeting the legal requirements of a national, state, or local government. If you are a citizen of one country, you have the right to live there, to work, to vote, and to travel. Now, let's discuss the modes in acquiring citizenship. There are two recognized forms of acquiring citizenship: by birth and by naturalization. By birth is subdivided into two groups: the jus soli and jus sanguinis. Jus soli is a Latin term that means law of the soil. Under the system, a citizenship is acquired from being born in a particular country regardless the nationality of your parents' citizenship. Jus sanguinis is a Latin term that means law of the blood, meaning to say a person's citizenship is based on his or her parents' citizenship. Regardless of where you were born, you have the right to citizenship in your parents' country. Another form of acquiring citizenship is through naturalization. Naturalization is an act of formally adopting a foreigner into the political body of a nation. Later, it will be discussed thoroughly. So the question is, who are the Filipino citizens according to the 1987 Philippine Constitution?
Now, I will go to discuss the 1987 Philippine Constitution, Article 4, Section 1. Section 1 provides that the following are citizens of the Philippines. First, those who are citizens of the Philippines at the time of the adoption of this Constitution. It refers to those who were already Filipino under 1973 Constitution under the still citizens of the time of the passage of the said Constitution. Second, to those whose fathers or mothers are citizens of the Philippines. Since Philippine nationality law is based upon jus sanguinis, thus if either one or both of your parents are Filipino at the time of your birth, then you are born with a Filipino citizenship. Third, those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. When a child's mother is married to a foreigner, the child will be considered as an alien and remains an alien until he elects Filipino citizens until it was changed. Under the 1987 Philippine Constitution, a Filipino that does lose her citizenship by marriage to an alien. Fourth, to those who are naturalized in accordance of law. It refers to those who are newly naturalized under the procedure provided by the law. Naturalization is the process by which Philippine citizenship is granted or foreign citizen or national after he or she fulfills the requirements established by the state.
There are two categories of Philippine citizens, the natural-born and naturalized. Natural-born Filipinos are citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. Those whose fathers or mothers are citizens of the Philippines at the time of their birth and those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority are considered natural-born Filipinos. On the other hand, a naturalized citizen is someone who was once a foreigner, then later on became a Filipino by legal fiction. Naturalized citizens are clothed by law with the rights and privileges accorded to as citizens of the Philippines, as well as bound by their duties to the state. In other words, they are also Filipinos. The government, through its three branches, can confer citizenship by naturalization. Hence, a foreigner can be naturalized in either of three ways. First, the administrative naturalization. This applies to native-born aliens who lived in the Philippines all their lives who never saw any countries and thought they were Filipino. This follows the Republic Act 9139 or the Administrative Naturalization Law of 2000. The second way is the judicial naturalization. If a foreigner is not qualified for administrative naturalization, then he will have to go through judicial naturalization. It follows Commonwealth Act 473 or the Revised Naturalization Law. The last way a foreigner can be naturalized is through direct act of Congress or legislative naturalization. This applies only for aliens who have made outstanding contribution to the country.
Section 3, Article 4 of the Constitution states that Philippine citizenship may be lost or reacquired in the manner provided by law. Two laws which provide the manner of loss of citizenship. First is Commonwealth Act No. 63, which provides that citizenship is lost by naturalization in another country, by express renunciation of citizenship, by subscribing to an oath of allegiance to support the Constitution and laws of another country, by rendering service to a foreign armed forces, and by deserting the armed forces of the Philippines. Second is Commonwealth Act No. 473, which states that citizenship is lost by cancellation of certificate of naturalization by court, by permanent residence in the country of origin for a period of 5 years from the time of naturalization, by an invalid declaration of intent in the petition, by failure to waive the educational requirements of the minor children, and by allowing oneself to use by a foreigner. Reacquisition of citizenship. As far as reacquisition of citizenship is concerned, Commonwealth Act No. 63 also provides that citizenship which was lost may be reacquired by naturalization, by a direct act of Congress, or by repatriation. Naturalization may be applied for by a former Philippine citizen who lost his citizenship under any of the aforesaid ways. For example, Pedro was a Filipino who became a naturalized citizen in another country, and as a result, he lost his Philippine citizenship. If he applied for naturalization and later on the court gave him a decree of naturalization, then he acquired his Philippine citizenship. The Congress can also reinstitute, by means of a law, citizenship to those who lost it. Repatriation is accomplished by taking the necessary oath of allegiance to the Republic of the Philippines and then registering the same in the proper civil registry and in the Bureau of Immigration. This is available to women who have lost their citizenship through marriage to aliens, those who lost their citizenship on account of economic and political necessity not otherwise disqualified by law, and deserters of the armed forces of the Philippines.
Republic Act No. 9225. Special note must be given to Republic Act No. 9225, otherwise known as Citizenship Retention and Reacquisition Act of 2003. It provides the natural-born citizens of the Philippines who lost their citizenship because of naturalization in foreign countries shall be deemed to have reacquired their Philippine citizenship upon taking the oath of allegiance to the Republic of the Philippines. After the effectiveness of Republic Act No. 9225, those who are naturalized in foreign countries shall retain their Philippine citizenship also upon taking the oath of allegiance to the Republic Act of the Philippines. Thus, under the present law, it is the taking of necessary oath of allegiance and registration of the same that retains and requires Philippine citizenship. Under Section 4, Article 4, mere marriage to an alien is not a ground for losing Philippine citizenship, unless there is implied or express renunciation through an act or omissions. For example, if Maria is married to Frederick, a foreigner, and in Frederick's country, his marriage is conferred on Maria their citizenship, then Maria will automatically lose her citizenship as provided by the Constitution. What she has is dual citizenship. But if Maria subscribes to an oath of allegiance to her husband's country,
Section 5, Article 4 states that dual allegiance of citizens is inimical to the national interest and shall be dealt with by law. Dual allegiance happens when a naturalized citizen of the Philippines maintains his allegiance to his countries of origin. For example, if Joey, who was a foreigner, becomes a naturalized citizen of the Philippines, and after naturalization, he still maintains his allegiance to his mother country, then his case is said to be one of the dual allegiance. This is prohibited by the Constitution to prevent a former foreigner who gained political membership to have false allegiance or pretend loyalty to the Philippines. Dual allegiance versus dual citizenship. The Constitution, however, does not prohibit dual citizenship. Dual allegiance is different from dual citizenship. Dual citizenship happens when an individual is a citizen of a two countries because the laws of both countries confer upon him membership of their state. For example, if Pedro's parents are Filipinos and he is born on the United States of America, he acquires Philippine citizenship under the principles of jus sanguinis and American citizenship under the principle of jus soli. Thus, he has dual citizenship because of the respective laws of the two countries. Another example is when a Filipino marries a foreigner and thereby acquires the citizenship of the spouse. There is also dual citizenship. The Filipino cannot prohibit dual citizenship because its law cannot control the laws of their state. Dual allegiance is prohibited because it is intentionally, while dual citizenship is generally unintentional, and that it is only accidentally caused by birth in a foreign state or marriage with a foreigner. Limitation on dual citizenship. Dual citizenship may be prohibited under special cases. For instance, pursuant to the Constitution. Republic Act 9225 requires that all those who are seeking elective public offices in the Philippines are execute to the personal and sworn renunciation of any and all foreign citizenship to qualify them as candidate in the Philippine elections.